Hey, Madison, how are you doing?
Good. How are you?
Good. Here we are again. It's still a pandemic. We've been doing these Facebook Live podcasts for well over a year now, and we're still doing it. Um, and we're going to talk today about one of our favorite topics, which is death. Um, in a pandemic, people are dying. We actually haven't you isn't this what you've perceived? We've just had a whole lot of after death legal work to do this year,
Yeah.
more than any other year, I would say. So what we're going to do today, we are going to revisit a topic that I did last summer. It was actually my most popular episode by far. We have more views on YouTube, more participation, more questions. That tells me that people need this information. So what I'm talking about is my trustee do's and don'ts. I did that episode last July. If you want to see part one, that's where you're going to look. Go to our website, absolutetrustcounsel.com, and watch the trustee do's and don'ts part one. And this is going to be part two. So we're going to be talking about some things that tend to trip up our trustees, and some of these things apply to executors also. But I just think there's a lot of need for more information out there. So this is what we're doing. And Madison, let's start with our surviving spouses. So sometimes a married couple often will have one joint trust, and the trust says if one of us dies, the other one carries on as the trustee by themselves. But a lot of times our surviving spouses don't realize they actually there are some things they have to do. And so let's talk about a couple of those things.
Sure. So sometimes people don't quite realize what kind of trust that they have, and they've set it up because they have a blended family, or someone was worried about a spouse remarrying after one dies, or they simply have a lot of money and the estate tax comes into question, and so they have to structure their trust for that way. And a lot of times, for all three of those scenarios, it's set up to where the trust splits after the first spouse dies, which creates work.
Right. And we do find this happens probably every month. We get a new client coming in who wants help with estate planning, and we discover, oh, your spouse died and you are supposed to split this trust into two trusts, and that they didn't know that. They had no idea. So that's something. I guess the moral of the story there is, if your spouse dies, go talk to your attorney and just figure this out. Is there something more that you have to do?
Yeah. And, or if you're not sure now and you're both still alive, maybe you should check in with your attorney and make sure that it's going to be a smoother process. Like, it doesn't have to be, as difficult as it might be if you check in now.
Right. That's a really excellent point, because something that really impacts that whole situation is the fact that the tax laws changed a few years back, and that trust that splits into two trusts isn't necessarily the best thing for everybody anymore. And Madison's point is, find out now. Once one of you dies, it's a lot more difficult. It's a lot more difficult. So just check it out. Okay. When that happens, though, when the surviving spouse comes in and we have to tell them, oh, you have this kind of trust that splits into two, there are options.
Yeah. I mean, the big option that, other than splitting it, which is the first option, right, which requires time and an extra tax return, which is an added expense and a lot of work, is that you could petition the court to allow you to modify the trust, especially if it's, a 15-year-old, you haven't updated it, tax laws have changed, and that's not the purpose for the trust anymore.
Right. And we do those all the time. So
Yeah.
in the right circumstance, in the right family situation, we can actually go fix that and address that problem by asking a judge to help us with that. And we've done that many times. But the other point, I guess, that I would make about that is, even if you are the surviving spouse and your spouse died several years ago, and you're hearing this now and saying, oh, I didn't do anything at all when my spouse died. It's never too late. We can go in and take care of these things, but it's so much better to do it sooner rather than later.
Yeah, because a lot of it's based on the value of assets, and it's much harder to use historical valuation, especially in our housing market. It's a lot harder to do that. Like right now, if you value something, it's probably going to go for way more than asking. So it's hard to actually get those valuations, historically speaking.
Yeah, it's everything's easier when you do it in real time, rather than trying to look back 5 years.
Yeah, or undo all the stock trades that you've done and have to that's difficult, because now you're talking about tax basis issues. It's already complicated. So we don't want to make it any more complicated than it already is.
Yeah. So if you take nothing else away from this, you surviving spouses out there, if you didn't talk to your lawyer sort of soon after your spouse died, do it now. Just do it. Okay. So let's talk about some things that apply to all of our trustees, not just surviving spouses. There are some notifications that we often find. Our trustee comes to meet with us. They've been working away, doing their job, being a great trustee, but they didn't realize there are some official notifications they are supposed to take care of, and they consequently didn't take care of it. So, Madison, what are the ones that we see that trip people up?
The first one is the Department of Healthcare Services of the state of California. They administer Medi-Cal, or California's version of Medicaid. And you have to notify them when anybody dies. Even if they're not receiving Medi-Cal, you still have to notify them, and then they'll let you know if there is any money that needs to be recovered, or that they're going to request to be recovered. Now, that doesn't mean that you have to pay this bill. It just means that it's there. If somebody was in a nursing home and they were on Medi-Cal, that money would be owed to Medi-Cal, but it's only recovered out of their probate estate. So if everything's in your trust, you don't have to worry about that so much.
Right. So the point is that if someone received Medi-Cal benefits during their lifetime, at least after the age of 55, when they die, Medi-Cal is entitled to come looking to be paid back. And for that reason, there's a law that says when somebody dies, anybody, whether they had Medi-Cal or not, the trustee and the executor and the attorney have a legal obligation to inform the Department of Healthcare Services. So they can check their file, they can figure out if they have a claim, and then they'll submit their claim if they have one. It doesn't mean they're going to get paid back. If you did your estate planning correctly, they won't, but you have to inform them. And if you don't, and you distribute all the money out, and then they find out that the person died and there's a claim, the trustee could be in a lot of trouble. That could be a big problem for the trustee, because now there's a claim and the money's gone. So don't do that.
There's a whole other set of laws that talk about what happens when the money's gone and various bills come to fruition.
Yeah. Right. Okay. So there's one other big one that we know.
Yeah. The assessor, if they own real property, the assessor's office has to be notified of a death of owner of real property in whatever county you own the property in. And that's required, I think it's within 90 days of death is what they require. I don't think most people follow that. But they don't send out bills. But that is essentially, they want to know that they can reassess taxes unless you've said that an exempt person now has the house.
Right.
Yeah.
And unless your situation is subject to an exemption, they're going to raise the property taxes.
Yeah.
And so, yeah, there is that requirement that you do it within X number of days. We haven't ever seen any penalty for getting it in late, but potentially, you know, if the property taxes are supposed to go up, that's going to happen effective as of the date of death, not whenever you get around to notifying them. They're gonna, so there's going to be a retroactive supplemental tax bill.
You may not get the financial penalty of filing late, but you're definitely going to get a bill for back tax.
You're going to get that bill. So you don't want to mess around with that. You definitely want to take care of that. Okay, so those are the sort of notifications to the governmental entities that we often see trustees just aren't aware of. But there's another big one that a lot of times our trustees aren't aware of.
Yeah. So the probate code requires that the trustee give official notice every time a trust becomes irrevocable, which is what happens when the trustor passes away. Whether it's a surviving spouse, it kind of depends on the type of trust that it is. But if anyone is a single trust or both spouses pass away, notice is definitely required. And it was required to go to all of the beneficiaries named in the trust and all of someone's legal heirs at law. So if they don't name a legal heir in the trust, that legal heir is still entitled to notice. And that includes everyone that's disinherited.
Right.
And,
right.
Yeah.
Yeah, and a lot of trustees are surprised to discover that there's this official legal notice that has to go out, because they say, well, you know, it's just me and my 3 siblings, and we all know that our mom has died. Yeah, that's fine, but the notice still has to go out to all of those people. And the purpose of the notice is?
It starts a statute of limitations running for 120 days from the date notice goes out for everyone to be able to contest the trust. So once that 120 days is over, they, in theory, cannot contest the trust anymore. And they're informed of that on the notice. Right. So it protects you as the trustee.
Right. So yeah, you as the trustee, you definitely want to do that, because once that 120 days passes, now you can be confident that nobody's going to come back and make another claim and say, oh, that money should have been mine. You can make the distributions, you can complete your trustee duties with confidence, knowing that this trust is valid and nobody's ever going to be able to take it apart. Yeah. So the other thing, and I think what's doubly surprising really to the trustees is that you have to notify people who aren't even beneficiaries.
Yeah.
Yeah.
And even if they wouldn't, like, they've had no contact for 30 years, they still have to be notified. And, you know, we see that a lot. And with surviving spouses, another reason to look at your trust is if you do have that AB trust and your spouse dies, you have to notify everybody and give them a copy of the trust. So if you think that, oh, the child you disinherited is not going to know until you're both dead, that's incorrect.
That's not true. Yeah.
So, you know, it might, that, depending on what your family situation is, that might be a good reason to update your documents if you don't want that. If that family would cause some family discord that you're not prepared to handle.
Right. So a married couple can have a trust that doesn't require notification to anybody until the second spouse dies. So that's possible, but you need to check. If that's what you want, you need to check and make sure that's the kind of trust you have. That notifying people who have been disinherited, who nobody has had contact with for years and years and years, that's always a surprise to the trustee.
I think everyone's biggest fear is that people are going to crawl out of the woodwork. I think even if you don't have anything, that's really like, you know, it's not really worth being sued over. I think everyone's biggest fear is that it's going to turn into, you know, a John Grisham situation where all these illegitimate children pop out of the woodwork and, you know, or claim to be at least, cause a headache, you know.
Right. Yeah. So the other thing I kind of wanted to touch on back when we were talking about notifying the assessor's office, This all has changed pretty significantly this year because of Prop 19, and we've done an episode on Prop 19 way back when, before we actually were stuck with it. But Madison, do you want to just talk a little bit about Prop 19 and how
Sure.
this works?
It used to be that we always filed a parent-child exclusion, which is what Prop 19, which is what we're talking. That's the part of Prop 19 that we're talking about is the parent-child exclusion.
So we're back to talking about property taxes.
Yeah.
Yeah.
So we used to file it for everybody, but now that the law changed as of this year, it's not always going to be filed. It's only going to be filed if the property in question was the decedent's primary residence and it's going to a beneficiary that's a child of the decedent or grandchild in certain circumstances, and it will be their primary residence. That is the only way that you get a break on the property taxes and the only time you have to file the parent-child exclusion form. So it's really important to have that family discussion if there's a bunch of siblings inheriting a property early on, because you want to get that filed. You have 3 years to file it, but if you don't file it timely in like the first year, they're still going to reassess the property, and then you're going to not probably have to get a refund. I mean, I don't even know if you can do that with the county. Good luck.
Yeah, yes. So getting that all sorted out, who is this property gonna be reassessed under Prop 19, or is it not? The earlier you can figure that out, the better, because they're gonna reassess it. They're not gonna wait for you. They're gonna reassess it, and then if it qualifies and you didn't file the forms, you're gonna be chasing after them to get your refund. And Madison says, I don't even know if you can get a refund.
Right.
I'm sure you can. I've seen it happen. But you don't want to be in that position, right?
It won't be timely, put it that way. So like, don't hang something that you need to pay with that refund check. You know,
right. And they're not going to pay you interest for the 6 months that they hung on to your refund. You know, you just don't be in that situation. Be proactive. Let them know as early as you can. No, you can't reassess this property. Okay. Yeah. Okay, so those are our, you know, sort of trustee do's and don'ts. That's our advice for this time around. We have, when we were talking about this episode a little bit ago, Madison said, we could do this episode every week. We would never run out of things to say. That it's a hard job. It's a hard job being a trustee.
Yeah.
And it, you know, you need guidance. So don't feel bad if you're a trustee out there and you've made some of these mistakes. It's okay.
No.
You know, it can be fixed. It can always be fixed. So I am going to turn to our questions because we do have a few questions. Let me pull up the questions that I've got. Okay, so what does the trustee do with all the furniture, dishes, and other stuff accumulated over many years that none of the children want?
That's a good one. So if none of them want it, at least no one's fighting over it. We'll just start there. So count your blessings. Yeah.
That's definitely a change from what we usually see.
Yeah. So if the trust doesn't call out for where items are to go, then the trustee's job is to sell everything off to the extent that, you know, the effort being put into a sale should not outweigh the profit that you get when you get it back. So like used sheets, you're probably not going to make a killing on that at a garage sale. So you just want to donate that and maybe take the tax write-off, you know, things of that nature. But you can sell as much as you can. There are people who do that. So if you don't want to do it, you can always hire someone to run an estate sale, clean everything out, donate, do all of it. You don't have to be the only person, you know, physically cleaning out someone's house.
Right. So my point, I think that I would add to that, and that's all very important. Don't spend $10,000 to have a garage sale that nets you $500. No, don't do that. But generally speaking, the trustee's job is to turn everything into cash. And if the beneficiaries don't want the stuff and the trustee can't sell it, or it doesn't make sense to sell it, it's a good idea to just get everyone to confirm in writing, yes, that's fine. Donate it to the Salvation Army. We're fine with that.
Yeah.
But so the trustee really, to protect themselves, shouldn't just say, oh, I'm just going to donate it. Just check with your beneficiaries and make sure that's okay.
Do you think that, because this is a big question that I get all the time, is how detailed of an inventory should one make when they're having the beneficiary sign consent? Should it just be all linens, all kitchenware, or do they need to,
I mean, I guess it depends on the family situation, but I would say you could say, every beneficiary has had an opportunity to walk through the house. They've taken everything they want. Everything that's still in the house as of today, fine. It doesn't, again, you don't want to spend a day and a half analyzing the contents of a home. That's it. And it probably would take way more than a day and a half. It was my house. I don't know about you, but I got, like 250 Santa Clauses.
Wow. I guess we'll revisit that in the Swedish death cleaning episode. We'll have to have.
Oh, yeah. Okay. So very sad. All right. Next question. What happens when someone gets that trustee notification? We're talking about that trustee notification, and they do have an objection. What happens?
They should notify the trustee and they should have an attorney, would be the first thing, just because that would be a lot less messier. But at that point, that all has to get squared away, and there's going to be most likely a court. Someone's going to file in court to petition to have the trust be validated or something like that. Depends on what the objection is, really.
Mm-hmm. Yeah.
What they're objecting to.
Yeah. But typically they're going to hire an attorney, and that attorney is going to file a petition in the appropriate probate court. That's how it proceeds. And then at that point, Madison and I say, whoa, litigation. And we refer it to our colleagues who handle litigation. We are planners, not fighters at Absolute Trust Counsel. Okay, and I got one more question here. Can the trustee fix up the house before selling it to get a higher sales price?
Yes.
What do you think about that?
I think they can. I think it depends how they do it. If there's, again, kind of like when we were talking about the personal property inside the house, if the effort is outweighed by the reward, then it might be worth it. If you're going to put $10,000 of trust money into the house and it's going to net you a $50,000 in equity type situation, then it's probably worth it. I think if it's depending on the situation with the beneficiaries, you'd want to get their permission or do what we call a notice of proposed action. And that would certainly be required if the trustee is going to lend money to the trust to do that as well.
Right. So that's an important point, is that you don't want to be spending trust money on a project like that isn't necessary. You can't sell the house if the toilets are broken. Right. That's necessary. But if you're going, wouldn't it be great if we had marble countertops in here before we sold it? The trustee needs to make sure the beneficiaries are okay with that expenditure. And so it might be informal. It might be you go through an official notice process, but we have ways to deal with that. And ultimately, our job comes down to making sure the trustee does it right and doesn't get in trouble. We're protecting our trustee by making sure they do things right. So yeah. Do you have anything more you want to add, or are we just going to put that aside, put everything aside, and do part 3 someday?
Yeah, definitely a part 3 someday. I think and 4 and 5. I'm sure it'll come up. Weird things come up every time, so it's just that you don't anticipate, because every family's different, every trust is different.
Yeah.
I mean, we laugh whenever we say it depends, but it really does.
Yeah, especially in a trust administration, in these after death matters, everyone is so different, and there aren't, we have general things that tend to happen, but everyone is different. It's always a puzzle to figure out, okay, how are we going to do this one? And so speaking of that, that's the end of our questions. But speaking of that, we at Absolute Trust Counsel, we are launching our trust administration roadmap process. And if you are clients of mine or professional colleagues of mine, you're going to be getting email information about this. But it's designed to sort of help trustees figure out the path to complete their project. We help you, we come up with a roadmap, we meet with you, we say, this is what you have to do from beginning to end. And it's one meeting for you, and you're ready to go. You can, you'll know exactly what needs to be done. And we're calling that Trust Administration Roadmap. It's a new sort of way of helping trustees. So this episode is kind of timely because we're launching that, and looking forward to see how well that works for our trustees. So look for that. If you aren't on one of our mailing lists, it'll be on our website and you'll be able to find that. So that's absolutetrustcounsel.com. And I am Kirsten Howe here with Madison Gunn, and we are so glad that you were here today to witness this, participate, and we look forward to connecting with you next time.